Recording in progress.
Good evening, one and all. Before we commence the continuing mediation education program today, I request all to raise for observing 2 minutes silence as a mark of respect for the departed soul, mediator Mr. Devraj, who passed away recently. Thank you all. Now I request Srimati Lakshmi Holla to invoke the blessings of Lord Almighty for the success of this month's continuing mediation education program.
వినాయక వినాయక నీను వినా బ్రోచుటకు వినాయక నీను వినా బ్రోచుటకు వేరే వరుణ రువిఘ్నరాజ వినాయక అనాథరక్షక 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 నీవేగారా అనాథరక్షక నీవేగాదా ఆదరించినను ప్రోవరా ఆదరించినను ప్రోవరాద వినాయకానిను వినా బ్రోచుటకు వేరే వరుణ రువిఘ్నరాజ వినాయకా సద్రసీరుహా సనయుగ చరణ సద్రసీరుహా సనయుగ చరణ సతతముషిత జన సంకటహరణ పరమ కృపా సాగర కరుణ పరమ కృపా సాగర కరుణ పాలిత జనగో పాలదాసనుత పాలిత జనగో పాలదాసనుత వినాయకాయనిను వినా బ్రోచుటకు వేరే వరుణ రువిఘ్నరాజ వినాయకా
Thank you, Lakshmi Madam, for the melodious rendition. May I request Srimati Jayashree Sridhar to do the welcome address and to introduce the dignitaries on the dais to the gathering.
Happy evening and a warm welcome to one and all present here. I'm honored to welcome Honorable Shri Justice Ashok S. Kinigi, Judge High Court of Karnataka and Governor, Karnataka Mediation Centre. Srimati Radha, Honorable Director, Karnataka Mediation Centre. Sri Gudi Basava, Deputy Director, Karnataka Mediation Centre. Sri D.R. Venkat Sudarshan, Retired District Judge. Respected members of mediation family, mediators of Dharwad and Kalburgi benches, mediators, district and taluk, and throughout the state. It's an honor to have the presence of all on this momentous occasion. Honorable Shri Justice Ashok S. Kinagi, enrolled as an advocate in the year 1995, practiced in High Court of Karnataka, Kalburgi bench from 2008 in the field of civil, land acquisition, and service matters. Served as panel advocate for various societies and financial institutions, to name a few: Hyderabad Karnataka Education Society, Gulbarga; Khaja Banda Nawaz Education Society, Gulbarga; Alstom Project India, Shahabad; Karnataka State Financial Corporation; Karnataka State Industrial Development Board; Ganesh Cooperative Bank, Gulbarga; Punjab National Bank, Gulbarga; Hutti Gold Mines, Hutti District, Raichur; Karnataka Power Transmission Corporation Limited. His Lordship took oath as Additional Judge, High Court of Karnataka on 23rd September 2019 and as Permanent Judge on 1st of March 2021. I request Honorable Director Srimati Radha to welcome Honorable Shri Justice Ashok S. Kinagi by presenting a plant. We welcome you, sir. It's an honor to have Shri D.R. Venkat Sudarshan, retired district judge, to have more insights on the subject of child custody under Mohammedan law. Sir has several remarkable accomplishments to his credit. My sincere apologies for not being able to read out all due to time constraints. I mention a few here. Sir enrolled as an advocate in the year 1978. From 87 to 2015, 2015, served as judicial officer and retired as principal district and sessions judge, Kalburgi. Post retirement, Sir is actively involved in various roles. To name a few, he was appointed as President, Consumer District Resolution Forum, associated with Karnataka Judicial Academy as one of the resource person, arbitrator on the panel of arbitration and conciliation, Central Bangalore, worked as adjunct professor in MS Ramaya Law College, Bengaluru, conducted training sessions to those aspiring to the post of judicial officers, and Sir has to his credit delivering lectures on importance of law and law course at various law colleges in Bengaluru, Mysore, Kalburgi, and Shimoga. Sir is a great speaker, having profound expertise, and is here to share insights on the subject child custody in Mohammedan law, a significant subject. Understanding the principles and intricacies of Mohammedan law concerning child custody is a crucial for mediators and legal practitioners to ensure fair settlements in child custody matters. I request Srimati Rajeshwari, mediator and coordinator, to welcome Sri Venkata Sudarshan by presenting a plant. We welcome you, sir. So, over to Mr. Srinivas.
Thank you, Jayashree Madam, for giving such a beautiful welcome speech. May I request Honorable Sri Justice Ashok S. Kinigi, Judge, High Court of Karnataka, and Governor, Karnataka Mediation Centre, to address the gathering.
Good evening to one and all. It is a great honor for me to be talking with you today on this very exciting occasion. I'm delighted to have an opportunity to address such a talented gathering of hardworking mediators. This is a great day for you, and I'm very happy to be sharing it with you on the topic of child custody and inheritance under a Mohammedan law. I speak in brief and detail. It will be, I think, my colleague will speak on the detail in topic in detail. Insofar as custody of a child under Mohammedan law is concerned, it is bound not only under Mohammedan law, it is also under the Guardians and Wards Act 1860 to 1890. If a boy is aged then below 7 years, and if a girl below puberty, then custody will be given to the mother or mother's mother or father's mother. Insofar as above 7 years, or if a girl above puberty, then it will be given to the father, that is parental grandfather and full brother. Insofar as if there are no male, totally there are three types of relationships. One is male, one is female, and another is male, and third is if there are no either male or female relationship, ultimately with the other relations. Other relations includes uterine brothers, father's uterine brother, maternal uncle. So in case, as I already told you, that in case if a boy is 7 years and girl below puberty, then custody will be given to a female relation, that is mother, mother's mother, father's mother. If it is above 7 years and suppose in case if there are no female relations, then it will be given to a male parental relations. And further, if a boy aged about 7 years and unmarried girl above puberty to the personal relation, female, male, or other relation. In case of a married girl above puberty, the custody right will be with the husband. In case of illegitimate children, the custody will be with the mother or her relations, not to the father. In the absence of male, female, or other relations, the custody of the child will be with the guardian appointed by the court, that is under the Guardians and Wards Act. And the purpose of custody of a minor is to see the welfare of the child and to protect the interest of the child. So far as inheritance is concerned, and further, the persons who are disqualified to be acting as a guardian is the person who is of a sound, who is a minor or unsound mind, or if a court comes to a conclusion that he is unfit to become a guardian. Under these circumstances, the person will not be qualified to be appointed as a guardian or custodian of a child. Insofar as inheritance is concerned, Muslim law is not a codified. It is based on a Quran or customs. Insofar as whatever is in a Mohammedan law, if the property will be inherited only after the death of a person. If a person dies, only then legal heirs can inherit. There are three types of heirs, class of heirs. One is sharer, that is Article 60 of the Mullah's Mohammedan law, and residuary Article 67. Sharer is Article 63, and residuary is Article 65, and distant kindred is Article 67. There are three types of sharers. One is already said that sharer, residuary, and distant kindred. Who is sharer? Now that defines under Article 63. Now there are two types of classes, schools of classes in the Mohammedan law. One is Shia and another is Sunni. Insofar as Chapter 7 deals with the Sunni, Chapter 8 deals with the Shia. Chapter 7, there are three types only in Shia, but as far as Sunni, in so far as Shia is concerned, only two types of sharer. That is only sharer and residuary. There is no distant kindred in the Sunni. Sunni. Insofar as when a person whatever is left after the death of a Muslim is heritable property, which is both movable and immovable property. After deducting, that is, the funeral expenses, expenses after obtaining probates, letters of administration, unpaid wages, or debts or legacy, or or dower to the widow. The Muslim law does not recognize any distinction between male and female, as like Hindu law. That is, in a Hindu law, Section 8 applies. As far as Section 15 is concerned, if a female dies intestate, then property is devolved upon the legal heirs as mentioned in the schedule. But here in a Mohammedan law, there is no distinction between male and female. In Section 8 of Hindu Succession Act, if a male dies living intestate, then the property devolve upon the legal heirs mentioned in the schedule. So here now I'll deal with section Article 63. Who are the sharers and the next residuary and distant kinder under the provision under the Shia? That is, Article 63 deals with sharers. Who are the sharers? Sharers are those who are entitled to prescribed share of inheritance, like father, grandfather, husband, wife, mother, grandmother, daughter, etc. More particularly shown in the table of share. Here there is a table in the Mohammedan law. There are two types of tables. One is one is a sharer and another is a residuary. So first column of this table contains the list of sharers. Who are the sharers? That is father, mother, that is father, grandfather, husband, wife, they are sharers. Second column specifies the normal share of each sharer. Third column specifies the condition which determines the right of each sharer to a share. Fourth column set out the shares as verified by special circumstances. So before drafting a plaint, when a party approaches or if a matter is referred to the mediator, then first you must go through the contents of the plaint and then you must decide what the extent of the assignment of share to the parties. So nowadays I have come across many judgments in Kalburgi, in Dharwad, and even in Bangalore also. Some judges they are passing a judgment in the suit for partition under Mohammedan law as if just like a Hindu law. They award a share in a, just like a Hindu law. That is, they are entitled for equal share. Not correct. That is not correct. So shares has been specified in the table. In a Muslim law, a definite share has been allotted, especially for daughter. She'll be entitled for half share. Son will be entitled for one share. That is, if a daughter gets a half share, that is half share. Son will get double the share of a daughter. So that this sharer will get a share only after the payment of funeral expenses and other expenses. Article 63 of chapter 7 of Mullah's Principal Mohammedan Law deals with inheritance. First share first share in the property has to be allotted to the sharer in case if there are no sharers, residuary. If there are no sharer and residuary, then distant kindred. In Shia, in so far as Article 55 is concerned, it says that if there are no sharers, or if there are sharers but there is no, if there is a residuary left after satisfying their claim. So here in this case, in under Mohammedan law, even if the property is there, first whatever the share which has been assigned in the table, first it has to be allotted to the sharer. Whatever remains, then it goes to the residuary. It goes to the residuary. So that says that Article 65 says that if there are no sharers or if there are sharers, but there is a residuary, after satisfying their claim, the whole inheritance or the residue, as the case may be, devolves upon the residuary. So first, property has to be allotted to the sharer. After that, then property will be assigned to the residuaries. That will be allotted to the residuaries. And further, residuaries are those who take no prescribed share, as just like sharers, but succeed to the residue after the claim of the sharers are satisfied more particularly shown in the table. That is, there is also table in the residuary. First sharer, next table is residuary. Yeah? Huh. The chart. Chart number 2. Chart number 1, sharer. As far as chart number 2 is concerned, residuary. Now, next is Article 67 provides that deals with the distant kindred. If there are no sharers or residuaries, the inheritance is divided amongst the distant kindred. That is, distant kindred are all those relations by blood who are neither sharers nor residuaries. So, distant kindred is neither they are only blood relatives. They will not be either sharer or residuaries. For them, if there are no sharers or residuaries, then the property will be inherited by distant kindred. Insofar as if there are only sharers, be a husband or wife, there will be no relation belonging to the class of residuary. The husband or wife will take his or her full share, and the remainder of the remaining of the estate will be divided among the distant kindred. So, if a husband or wife is there, after allotting a share to them, then it will be distributed in the amongst the distant kindred. Now, as I spoke about Sunni law, now Shia is also separate. Chapter 7, Chapter 8 provides Sunni, that is law of inheritance by Sunni. There are only two types of class of heirs in Sunni. One is sharer and residuary. There is no distant kindred in uh, Shia. Article 90 deals with the table of sharers. That is same thing as that in Sunni. As far as 91 deals with Article 91 deals with the residuary. There is a distinction between Shia and Sunni only in regard to the table, that is preference and quantification of a share. Rest other thing it is common. General principle is common. The difference between Shia and Sunni, that is table, sharer and residuary, is preference and quantification of a share. And rest other thing, all the general principle is applicable to both Shia as well as Sunni under the Mohammedan law. And even in the Shia also table contains name of sharer and what mentioned in table chart number 1 of Sunni. Same thing also follows in this one, except quantification of share. Now, who are disqualified from the inheritance? That is a person who has committed a murder, or in case if an illegitimate child can inherit only from the mother and not from a father or from her relation, mother's relation. Child in the womb, if not born alive. Fourth is, if a Muslim marries under a special marriage act, then he ceases to be a Muslim under law of inheritance. So these persons will not be are disqualified from inheritance. And next, so that is, I summarize my this one. First step is the in distribution of the estate of the deceased Mohammedan is after payment of funeral expenses, debt, legacy, and is to allot their respective shares to such a relation as belongs to the class of sharers, residuary, distant kindred, and next is and further, in this case, under Mohammedan law, if somebody comes and approaches you to draft a will that I want to bequeath the entire property, that is not permissible, that is impermissible. If you want to bequeath the property under a Mohammedan law, you can bequeath only to the extent of 1/3, not more than that. If you want to bequeath more than that, then you have to take a consent of other legal heirs. Suppose in case if a Mohammedan wants to gift, you call it as a hiba. Under Mohammedan law, gift, you call it as an hiba. So if you want, you can give the property without the consent of a co-sharer. Here, in this case, if under Mohammedan law, if a person who acquires a property, he will become an absolute owner till his death. If he doesn't bequeath the property one third, or if he doesn't give the property. So many advocates will not be knowing that while drafting a will, they simply draft and say that all the properties are bequeathed in favor of that we are committing a mistake. And as far as hiba is concerned, you can orally give the property under Mohammedan law. But in order to prove the gift oral hiba, there are three essential ingredients you have to fulfill: offer, acceptance, and delivery of possession. If either one of the ingredient is absent, then the gift will become invalid. So my request to all the advocates is, when a matter is referred to mediation, first you should take a chart. First you should ask the parties whether they are Shia or Sunni. If they are Shia, then see the chart. If they are Sunni, then you see the chart, and then you determine the share to what extent. In this chart A, that is sharer, father will get a 1/6 share when there is a child or child of a son. When there is no child or child of a son, true grandfather will get 1/6 share. Husband will get 1/4. Wife will get 1/8 share, and mother will get 1/6 share. So by going through the chart, you can decide the shares. So this is all. I thank the director for providing me an opportunity to speak on this subject. I also thank all of them for having a patience hearing. Thank you, one and all.
On behalf of KMC, I wholeheartedly thank Honorable Justice Sri Ashok S. Kinigi for his enlightening and very informative speech on Mohammedan law. We are very lucky and blessed to have you here, sir. So our request is to visit us often and share your expert knowledge with us to enlighten us. Thank you, sir. May I request Sri D.R. Venkat Sudarshan, retired district judge, to speak on child custody and inheritance under Mohammedan law.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. Very fine good evening to one and all. My Lord Honorable Justice Ashok S. Kinigi, Judge High Court of Karnataka, and the Governor of this esteemed Mediation Centre, Honorable Director Madam Radha, Deputy Director Mr. Vasudev, and all the learned respected mediators. I welcome you all to this session. At the outset, I express my sincere thanks with a deep gratitude to the Board of Governors of this Mediation Centre for having provided me this opportunity of standing before you in this beautiful evening to share my few thoughts on the important subject of Mohammedan law, important branch of Mohammedan law. I once again thank you, sir. Thank you, madam. With all humility and humbleness, I would like to make one statement that I am not an expert in the subject. nor I am a good orator. Whatever the little thing that I have learned out of my experience, and whatever the little thing that I have learned from my reading, I would like to share my thoughts before you. If there is any mistake, kindly excuse me. The topic which has been slated for today's discussion is Mohammedan law of inheritance and the child custody. Both are really very voluminous subject. It may not be possible to cover the entire subject within the available time. So whatever the time that is available and to the extent possible, I would like to cover this. Who is a Mohammedan? Who is a Mohammedan? According to Article 19 of the Mohammedan law, any person who professes Islam and acknowledges that there is but one God and Muhammad is the Prophet is a Mohammedan. There are only two requirements to qualify a person himself as a Mohammedan. Number one, he must acknowledge that there is but one God. Number two, that Muhammad is the Prophet. The article also further says that a Mohammedan need not be only by birth. He could be a convertee also. He can get a person who gets himself converted from other religion could also become a Muslim, could also become a Mohammedan, provided he adheres himself to above said two requirements. That is, that there is but one God and Muhammad is the Prophet. The law further says that it is not even necessary that he should be a believer of orthodox things of the Mohammedan law, Islamism. He remains to be a Muslim as long till such time that he renounces the religion and embraces another religion. The law further says that merely because a Mohammedan is adopting the Hindu form of worship, that itself will not be sufficient to say that he is not a Mohammedan. Why I am giving these definitions in an exhaustive form is you are all advocates too and mediators. So whenever you have an occasion to file a litigation before a court, first of all, you must be able to satisfy yourself as to whether the fellow comes within the definition of Article 19 of the Mohammedan law. After said this, of course, my Lord has already said all those things, but since my Lord has asked me to, amplify the things, I am just, with the permission, I am amplifying it. There are four sources of Mohammedan law. Number one, the Holy Quran. It is a document, or it is a holy document which has been accepted by the entire Muslim community all over the world. This is the first source. It is said that there are about 6,000 verses in Holy Quran. Number two is Sunnah. That is practice and precepts of Prophet Muhammad, which is not in writing, but which is being followed traditionally. I once again repeat, Sunnah is a practice and precept of Prophet Muhammad, which is not in writing, but which is being followed traditionally. Number three is Ijma. Ijma is a consensus opinion arrived by the learned men of the community on any point that has referred to them for dispute resolution or for a solution. Then the fourth one is Qiyas. That is analytical deduction of what is right and just according to Mohammedan law. These are the four sources of Mohammedan law. And except this, of course, I have not come across anything, any other thing. If anybody knows it, I will also be very happy and I will also learn about it. Thereafter, the next topic is, as my Lord has already said, there are two schools of Mohammedan law. One is Sunni, another one is Shia. Among Sunnis, there are four classifications: Hanafis, Malikis, Shafis, and Hanbalis. Once again, I repeat: Hanafis, Malikis, Shafis, and Hanbalis. Among Shias, there are three categories: Itna Ashriyas, Islamists, and Zaidiyas. In India, it is said in the book itself, in India, the majority of the Muslim population are Sunnis. Majority of the Muslim population are Sunni. Therefore, the book further says that if any case comes before a court, the presumption is that the parties are Muslims. If any case comes before a court filed by a Muslim against a Muslim, the presumption is that they are Sunnis and Hanafis. If at all the parties, the plaintiff or the defendant, wants to contend that they are not Sunnis, they are Shias, it is for them to specifically plead that they are not Sunnis and they are Shias. Otherwise, the accepted position of law is that in India, since majority of the Muslim population being Sunnis, they are presumed to be Sunnis, and Hanafi school of law is being applied to them. This Hanafi school of law among Sunnis was founded by Abu Hanifa. He had two disciples, the sources I am talking about. He had two disciples, one by name Abu Yusuf and another by name Imam Muhammad. Whenever there used to be a differences of opinion between the master on the one side and two disciples on the other side, the opinion of the disciples used to prevail, not the opinion of the master. Whenever there used to be a difference of opinion between that of a master, differences of opinion between the two disciples, then the opinion of that disciple, which coincides with the opinion of the master, used to prevail. That was the way in which the decisions were being taken earlier. Now, coming to the inheritance. So far as the succession of the property is concerned, as all of us know, there are only two modes. One is testamentary, another one is not testamentary. If a person executes a will, expressing his intention as to how the property belonging to him should pass and to whom it should pass after his demise, that is called as a testamentary disposition, we all of us know. And in a non-testamentary disposition, the succession opens only on the death of a person. And it will go to such of those persons to whom it has to go according to the law which governs the parties. This is a general, explanation, not particularly applicable to Muslims or Hindus or whatever it is. Now, before we talk of inheritance, we have to see certain basic principles which are applicable to the law of inheritance of the Mohammedan law. As my Lord has already put it, the first one is the property which is capable of being, which is heritable. As my Lord has already stated, there is no difference between a movable property and an immovable property under the Mohammedan law. And the property which is heritable is only that property which is available on the death of a person, on the date of death of a person. It is only that property which is available for succession or division, whatever it is. And the second aspect is the property which is available for distribution among the persons who are entitled under Mohammedan law is after deducting expenses towards statutory or admissible expenses. I will let you know what are those expenses a little later. The third principle is that under Mohammedan law, there is no concept of joint family. There is no concept of ancestral property. There is no concept of co-personary property or a co-personal. I am stressing this because it has been, I have also noticed when I was taking classes in the academy that the judges used to put a question. Sir, we are coming across cases wherein the plaintiff, being a Muslim, he pleads filing a suit for partition. He feels that he is a member of a joint family and the property is an ancestral property. How to go about? That is why I am telling, under Mohammedan law, there is no concept of a joint family. There is no concept of an ancestral property. There is no concept of a co-partner or a co-partnership property. Then number two, mere birth in the family does not guarantee any right under Muslim law, unlike Hindu law. In Hindu law, if a person takes a birth, he will be entitled for a share. What will be the share? That depends at the time of division. He will be entitled for a share in the property by birth because he has taken birth in the family. But under Mohammedan law, no. No right in the property is guaranteed merely because the birth has taken place in the family of a Mohammedan. Because, as I have already told, that the succession opens only on the death of the person. On the death of the person whose property has to devolve. Till such time, there is no question of succession. So, there is no guarantee that merely because a person has taken birth in a family of a Mohammedan, he will have a share in the property. If he is alive, surviving, as on the death of the propositus, he may get a share in the property as per the law laid down, as my Lord has put it, depending upon the matter, whether he comes under the category of a sharer or a residuary or a distant kindred. Then there is no doctrine of representation. There is no doctrine of representation under Mohammedan law. What do you mean by a doctrine of representation? I think I can explain this to you with an illustration. Let us say that P is the propositus. Propositus is the person whose property has to be divided, has to be distributed. Let us say that P is a propositus. He has two sons, A and B. A has two sons, C and D. B has one son, E. Please keep this in your mind. I mean, if you want, you can make a note of it also so that you will be able to understand it better. P is the propositus. He has two sons, A and B. A has two sons, C and D. B has only one son, E. Now, so C, D and E are the grandsons of the propositus. Now, in this case, A and B, being the sons, would inherit the property had they been alive as on the date of death of the propositus. Now, let us take, for instance, for our understanding, that B predeceases propositus. He died before the death of the propositus. What is the position? In Hindu law, I am making a comparison. In Hindu law, if a son dies, his grandson, the son of a son will get a share. The daughter of a son will get a share. But under Mohammedan law, no. If B is dead, if B's death has taken place prior to the death of the propositus, B will not get any share. Similarly, his descendants will not get any share. That means to say, there is no doctrine which could say that a person can represent the estate of the deceased. There is no doctrine which could say that a person could claim or represent the estate of the deceased who is otherwise entitled for a share in the property of the propositus. This is another important principle which has to be kept in mind. Because supposing a suit is filed where the plaintiff claims a share in the property on the ground that the property belonged to his grandfather and that his father, that the plaintiff's father is no more. Therefore, I am entitled for a share in the property that would have fallen to my father had he been alive. No, such a plea is not available under Mohammedan law, though it is available under Hindu law. I requesting this because please be, as my lord has already put it, please be careful when you are drafting the plaint. These are the important finer things which are to be kept in mind when plaint or written statement is going to be filed, when pleadings are to be prepared. Then, under Mohammedan law, there is no difference between a male and a female in the sense, as my lord has already put it, we have section 6 and 8, which speaks of a succession in case of a male. We have section 15, which speaks of succession in case of a female dying intestate. And in class 1 years, there are about 23 years, which includes the female heirs also. But in but that means that the shares will change. Under Mohammedan law, whether it is a female who dies or a male who dies, there is no change in share ratio. It will remain same. So whether it is a male or a female, who is a propositus, that is, who is dead and whose property is available for distribution, that makes no difference, that makes no distinction. That is another important aspect which has to be kept in mind. Then doctrine of primogeniture, which we have in Hindu law. Of course, now it is not being practiced. That is, the eldest son will have a higher share, Jeshta Bhaga. In the traditional Hindu law, we used to call it as a Jeshta Bhaga. That is also not recognized under Mohammedan law. Then, a stepchildren. Stepchildren are not at all entitled for a share in the property of a stepfather or a stepmother. Similarly, a stepfather or a stepmother cannot claim any share in the property of a stepson. That is another important aspect which has to be kept in mind. Earlier, perhaps before the section 108 of the Evidence Act came into force, whenever there used to be a simultaneous death of the persons who are entitled for a share, let us say, for example, A and B are the persons. If A dies, B will get A's property. If B dies, B will get A's property. If both of them die simultaneously, say in an aircraft accident, or say in a train accident, or in some accident, both die simultaneously, the general law is, it's presumed that the younger survived the elder. So the elder died first and younger died later. That is the common 108 of the Evidence Act which says. But under Mohammedan law, no, that is not applicable. When both have died in the same crash or in the same incident, neither A can claim a share in the property of B, nor B can claim a share in the property of A. Then whatever the division, however the division, it will have to be made according to the classification in which the heirs will come, whether as sharers or residuaries or distant kindred, it will be decided accordingly. Of course, as my lordship has already put it, if a person has got married under a special marriage act, he will be disqualified from claiming any share in the property. Now, the next aspect to be considered is, what is the property which is actually available for distribution? If a person has got, say, 1,000 rupees worth of property, whether the entire 1,000 rupees can be distributed among the heirs is the next aspect which needs to be considered. According to Article 39 of the Mohammedan law, no, before ascertaining the actual property which is available for distribution, amount to meet certain expenses will have to be set apart. What are they? Number one, funeral expenses and deathbed charges. Funeral expenses and deathbed charges. Number two, debts, DBTS, debts due by the deceased should be deducted. Whatever the debt that the deceased was owing to others as on the date of death, that will also be deducted from the property left behind by him. Number 3, wages due for services of labor, artisans, and domestic servant for a period of 3 months shall be set apart from the property of the Muslim that is available for division. Number 4, of course, my Lord has already said it, but anyway, I'm repeating it again. If a Muslim wants to will away his property, execute a document by way of a will, he cannot do it to the extent of more than 1/3 of the total property. So once the will is there, that will has to be probated. For probating a will, expenses will have to be incurred. So that expenses also should be set apart from the value of that 1,000 rupees property which belongs to the propositors. So after setting apart setting apart that portion of the property which is required for the purpose of meeting these expenses, then whatever the property or the net amount that is available, that is only the property which is available for distribution. In the example which I have given, supposing, for example, if that person has left a property worth rupees 1,000 rupees, and the total of all these expenses would come to 100 rupees. So 1,000 minus 100, only 900 rupees is available for distribution and not 1,000 rupees. This is another important aspect which has to be kept in mind. Now coming to the distribution of shares. So far as the distribution of shares are concerned, as my Lord has already said it, there are 3 classes of heirs under Mohammedan law. Sharers, who are also called as Quranic sharers, residuaries, and distant kindred. The sharers are those persons who are almost in the closest circle of the deceased. Who are in the closest circle of the deceased. In the chart which you have seen, there are about 12 relations which has been set out in the form of a list which shows that they are the sharers. This is very important. The wife, mother, true grandmother, I will come to that later, what is true grandmother, daughter, son's daughter, uterine brother and uterine sister, full sister, consanguine sister, husband, father, true grandfather. These are the persons who are labeled as sharers. Who are labeled as sharers. The peculiarity of the Mohammedan law is, it is here that we have to distinguish ourselves from Hindu law to Mohammedan, because as all of us know, that number of cases which come before the court for partition in respect of Mohammedans is very, very less as compared to Hindu law. We are all acquainted, we may be well versed with the Hindu law, because day in and day out we are getting. Sorry, my lord, if I have. Shall we continue? So there are 12 classes, 12 relations which have been mentioned in the list of sharers. Why I am emphasizing this is, if you have a close perusal of that particular list, you will come to know that the share of everybody is defined. Share of everybody, every heir is defined. Meaning thereby, he is not entitled to get more than what is defined there. Please compare for a moment with Hindu law. I told you already in class 1 year, there are 23 relations. Even if one person is alive, he will get the entire property of the deceased. But in Mohammedan law, it doesn't happen so. In Mohammedan law, supposing the husband dies, wife alone is living. Wife will get only 1/4 share, nothing more than that. Only 25 rupees out of 100 rupees. She will not get the entire property. So, sharers are those persons who have been categorized in the list of sharers. Under Mohammedan law, there are 12 such legal heirs which have been enlisted there, and all of them have got a defined share. Then residuaries. The word itself indicates residue. Whatever that remains after allotting the shares to the living sharers as on the date of the death of the deceased Mohammedan, whatever that remains as on the date of the death of the deceased Mohammedan after distributing it to the sharers, that will go to the residuaries. So the residuaries are second class. They will get a share in the property only when it remains after distributing the sharers. If no property remains, they won't get any share. So, residuaries are those persons. Even the list of residuaries also has been given in the Mohammedan law. So, the residuaries will get a share in the property only after distributing the shares in a defined proportion or mentioned in the list of sharers to the sharers who were alive as on the date of the death of the deceased Mohammedan. This is a very, very important thing that we should know. As I have given you example, B, though he is the son of the propositors, and though he has got a son, he was not alive as on the date on which the Mohammedan died, propositors died. So B will not get any share because he was not alive as on the date of the death of the propositors. So therefore, I am stressing this sentence saying that only those persons who were alive as on the date of the death of the deceased Mohammedan, be a male or a female, as on the date of the death of the deceased Mohammedan, it is only they who are entitled for a share and no others. Then distant kindred. If the distant kindred is a special category of persons, they will get a share in the property only when there is no residuary and there is no sharer and there is no residuary. Otherwise, the distant kindred will not get any share. But there is an exception to that rule. I will come to that later. There is an exception. How they have to? That's what I'm telling. In the book itself, the list has been given. Who are all the sharers? Who are all? I will come to that. I will come to that. Just I told you when the sharers will be entitled, when the residuaries will get, and when the distant kindred will get. The distant kindred will get will get share in the property only when there is no sharer and no residuary. But there is an exception to that. I will come to that later. There is an exception to the general rule. Now, another peculiarity of Muslim law is if you see sharers list, you will be surprised to know because we are all versed with Hindu law. Yes, madam? This is more comfortable for me, madam. Nanu kushi aguttalla. I feel more comfortable. I feel more. No problem, no problem, no problem, no problem. I was telling something. Hmm? Yes. You will be surprised to know on seeing the list of sharers that because we are all versed with Hindu law. Hindu ನಮ್ಮ ಇದರಲ್ಲಿ ಒಂದೇ ನಪುತ್ರ ಗತಿರ್ ನಾಸ್ತಿ ಮಗ ಇಲ್ಲ ಅಂದ್ರೆ ನಮ್ಮ ಮೋಕ್ಷವೇ ಇಲ್ಲ ಅಂತ we believe in that. So we give prime importance to the son under Hindu law. If you see list of sharers, you don't find the name of a son. The son's name doesn't find in the list of sharers. The son's name is found in the residuary. And daughter's name is found in the list of sharers. But there is a rule added. What is that rule? If the deceased has not left behind a son, and if he has left behind only a daughter, the daughter will get 1/2 or the share in the property of the deceased. Repeating it again. If the deceased has not left behind a son and has only left behind only a daughter, the daughter will get half share in the entire property of the deceased Muslim. But If the deceased has left behind a son, then daughter will not get a share as a sharer. She will get only as a residuary. To improve it further, if the son is there, the son will get half a share and the daughter will get only one third. If there is more than one daughter, all the two daughters put together will get two-third share. This is one of the important distinction which we are expected to know so far as the list of sharers is concerned. So far as the father is concerned, whenever I say the relationship, you relate it to the deceased. Whenever the father of the deceased is alive, if the father of the deceased is alive, he will get only 1/6 share if the son of the deceased is alive. If X is the person who died, let us say, for example, X died leaving behind his son Y. X's father is A. So X as a father will get 1/6 share provided if there is a son. If there is no son, then he will be getting a share as a residuary also. How? I will explain to you later. So as a sharer, he will get 1/6 share when the deceased has left behind his child, or child of a son. As a residuary, he will get the residue after distributing to other sharers. Supposing there are other sharers apart from the father, whatever the share that is allotable to them after distributing them, if there is anything that is left out, father will get that property as a sharer also under Mohammedan law. Then mother will get 1/6 share when there is a child, that is child of the deceased, or child of the son alive. She will get 1/6 share. When there are two or more brothers or sisters, or even one brother and one sister, she will get 1/6 share. As a sharer, she will get 1/3 share when none of these relations are alive. That is so far as the mother is concerned. I'm just telling you the uh, finer things of the Mohammedan law with allotment of shares. Huh? Mother will get a one thing. Mother as a sharer, she will get 1/6 share when when there is a child of the deceased, or child of a son of the deceased. ಅಲ್ಲಿ child ಅಂದಿದ್ದಾರೆ, ಸನ್ನು ಡಾಟರ್ ಅಂತ ಹೇಳ್ತಿಲ್ಲ. Kindly make a note of difference. They don't say son or daughter, they say child of a son. It could be a son or a daughter, whoever it is. And when there are two or more brothers or sisters, or even one brother and one sister, whether full or consanguine. As a sharer, she will get 1/3 share when there is no child of the deceased, or when there is no son of the child alive. She will get 1/3 share. That is how the property will devolve upon the mother. Then, in general, when a female dies, her husband will get 1/4 share if there are lineal descendants. 1/4 share. I repeat it again. When a female Mohammedan dies, leaving behind a son or a daughter, a lineal descendant, then the husband will get 1/4 share in the entire property of the female. Supposing that female dies without leaving any lineal descendant, then the husband will get half a share. That is so far as the death of a female is concerned. If a male Mohammedan dies, leaving behind a son or a daughter, then the wife will get only 1/8 share. And if there is no lineal descendant, wife will get 1/4 share. That is another important aspect. Third, coming to the daughter. As I have already told, if there is no son alive, daughter will get one third share. Sorry, half a share. If there are more than one daughter, if there is more than one daughter, all the daughters put together will get two-thirds share. Like that, we must go on analyzing the shares of each and every person, keeping the chart on hand. And then you can pray, you can make a prayer, operative portion of your pleading, where you are praying for a allotment of a particular share that should be in consonance with the relations mentioned in the list of sharers and the shares which have been defined to each one of them. You cannot apply the Hindu law and ask for a share as per Hindu law in respect of in a case where both the parties are Muslims praying for a share in the partition. Then there are two words used: true grandfather, false grandfather under Mohammedan law. What do you mean by a true grandfather and a false grandfather? A true grandfather is one who is a male ancestor between whom and the deceased no female intervenes. Maybe a little bit difficult to understand. A true grandfather is one who is the ancestor of a deceased, and between this true grandfather and the deceased, there is no female intervening. Example, the father of the deceased. There is no male in between. Father of the deceased, father's father, father's father's father. These are all called as true grandfathers because there is no female coming in between this relationship. That is between this man and the deceased person. They are called as true grandfathers. True grandmother, same explanation. Means a female ancestor between whom, that is that ancestor, and the deceased, there is no false grandfather. Now, first let us see what is false grandfather, then we will be able to understand this. That means, I will come to that later. Father's mother, mother's mother, father's mother's mother, all female intervening there. Father's mother's mother, mother's mother, mother. These are the true grandmother, true grandmother. Uterine brothers and uterine sisters. They are the children of one mother but different fathers. Uterine brother and uterine sister are the children of one mother, a common mother, but different fathers. They are also entitled for a share equal to 1/6 share as sharers under Mohammedan law. Because the Muslim law recognizes always the female right more than the male right. You go to any, but ratio is less. Even though they recognize that a male will get 50 paise, female will get 25 paise. It is always in the 2:1 ratio between the male and the female. A consanguine sister is one where there is a common father but different mothers. A common father and different mothers. So these are the wordings which are to be kept in mind when we are thinking of a law of inheritance relating to Mohammedan law. Now, so in the list of sharer, there are 12 heirs. Their shares are defined. They will get a share according to the defined share only, not even a single paise more, even if it is available. I told you if 1,000 rupees is there, if there is a sharer who is entitled for 1/8, that will get, he or she will get only 120 rupees, not more, 125 rupees, not more than that. So rest will be there, 875 rupees. If there are other sharers, they will also get their share according to the defined shares in the list of sharers. After distributing the property according to the defined shares to the list of sharers mentioned in list of sharers, whatever that remains, that will go to residuaries. Now, who are residuaries? Residuaries are descendants, ascendants, and collaterals. What do you mean by descendants, ascendants, ascendants, and collateral? ಸತ್ತವನ ಮಕ್ಕಳು, ಸತ್ತವನ ಹಿರಿಯರು, ಸತ್ತವನ ಜೊತೆಲಿ ಹುಟ್ಟಿದವರು. ವೆರಿ ಸಿಂಪಲ್. ಡಿಸೆಂಡೆಂಟ್ಸ್, ಸತ್ತವನ ಮಕ್ಕಳು. ಅಸೆಂಡೆಂಟ್ಸ್, ಸತ್ತವನ ಹಿರಿಯರು. ಕೊಲಾಟರಲ್ಸ್, ಸತ್ತವನ ಜೊತೆಗಿರೋರು. ಅಣ್ಣ ತಮ್ಮಂದ್ರು. ಸೊ ಅಣ್ಣ ತಮ್ಮಂದ್ರು ಇನ್ನೂ ಬೇರೆಯವರೆಲ್ಲ ಹೇಳ್ತಾರೆ, ಯಾರು ಸೇರ್ತಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ. ಸೊ ಡಿಸೆಂಡೆಂಟ್ಸ್, ascendants, and collaterals are the persons who are residuaries. See, in sharers, we don't have that classification. This is one speciality in the list of sharers. Now, descendants, son, son's son, son's son's son, etc. How low soever. They are all descendants because they are born to the son and his family. So they are descendants. Ascendants, father, father's father, father's father's father, like that. Ascendants. Then collaterals, full brother, full sister, consanguine brother, consanguine sister, full brother's son, consanguine brother's son, full brother's son's son, consanguine brother's sons. They are the collaterals. Then there is one more classification, collaterals of the father of the deceased. Look at that, collaterals of the father of the deceased. Andre, appa, chikkappa, doddappa, hige. Collaterals of the father of the deceased. So these are the residuaries. So when there are so many persons in the list of residuaries, how to distribute the property? The question will automatically, at least in sharers we have a defined share, but in list of residuaries we don't have a defined share. Then how to divide the property? The law is very simple. After distributing shares to the available sharers as per the table, that is as per the defined shares, whatever the property that remains, that will have to be distributed among the residuaries. How? First, the residuaries to be first distributed, the residue shall be first distributed among the descendants. ಮಗ, ಮೊಮ್ಮಗ ಎಷ್ಟಿದೆಯೋ ಅಷ್ಟು ಅವರಿಗೆ ಕೊಟ್ಬಿಡ್ಬೇಕು. In next door ಕೊಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. Because the residue, they will get the remaining property. I told you already, no? Supposing the husband dies, leaving behind only the wife, no other sharer. Wife will get only 1/4. Remaining 3/4 will go to residuaries under Mohammedan law. If there are no descendants, then ascendants. Father, father's father, father's father's father. If there are no descendants, ascendants, then it will go to collaterals. If there is no collateral, then it will go to the collaterals of the father of the deceased. Even if one person is alive in that particular branch, he will take the entire, whatever that remains after distributing to the sharers, he will take the entire share. This is what the list of residuaries is, and this is how the residuaries will get their share. So residuaries do not have a fixed share. The nearer in relationship, in the degree of relationship, excludes the remote. The nearer in the degree of relationship excludes the remote. And there is no distinction between, and so far as residuary is concerned, there is one important aspect to be kept in mind. It is only male relations. No female relations are there in the list of residuaries. This is another important aspect to be kept in mind. Now, distant kindred. I told you already, general rule is, if there is no residuary, if there is no sharer, if there is no residuary, not even a single person, then only whatever the property that is left behind by the deceased, that will go to distant kindred. So first sharers are to be given. After distributing the property among the sharer as per the defined shares, if any property remains, it will go to residuary. And there is no question of giving any share to distant kindred, because even if there is one residuary, he will get the, whatever the residue is there, he will get the entire residue. So there is no question of giving any share to distant kindred. The distant kindred will get a share in the property only when there is no sharer and no residuary. This is one general rule. But I told you that there is an exception to that. What is that exception? I mean, of course, even among the distant kinders, you have descendants, ascendants, collaterals, and the descendants of the father of the deceased. The same category of classification as you have in the list of residuaries.
But genealogical tree is very difficult to establish this type of relationship among the
Sorry.
genealogical tree. To prove it is very difficult in this Mohammedan
No, you
Law.
have to prepare a chart. When a client comes to you, you must trace his relationship to the deceased first.
Mm,
How are you related to the deceased?
mm.
You must trace his relationship to the deceased. Then you will come to know whether he will come in the list of sharers or he will come in the list of residuary or in the distant kinder. That is how you have to ascertain. Much job is of the advocates only. Normally, if I'm sorry, if I'm wrong, kindly excuse me. If I am wrong, kindly excuse me. ನಾವು ಏನ್ ಮಾಡ್ತೀವಿ ಲಾಯರ್ಗಳು ಅಂದ್ರೆ ಕ್ಲೈಂಟ್ ಹೇಳಿದ್ದನ್ನೇ ವೇದವಾಕ್ಯ ಅನ್ಕೊಂಡ್ಬಿಡ್ತೀವಿ. We believe the client. I don't say we should not
ಇಲ್ಲ
believe the
ಇಲ್ಲ
client. We have to believe the client. But one thing should be kept in mind. No client who comes to you will speak the truth. No client who comes to you will speak the full truth. He will only give so much of information which suits his convenience. It is only the art of advocacy. When you go on digging at him, when you go on putting questions to him, then he will reveal one after the other. So the entire job of an advocate is in doing exercise with that client and extracting all the information and then preparing the plate. ನಮಗೇನು ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಮ ಕ್ಲೈಂಟ್ ಹಂಗೆ ಹೇಳ್ದೆ ನಾನು ಬರೆದು ಬಿಟ್ಟಿದ್ದೀನಿ ಅಂತಂದ್ರೆ ಅದಕ್ಕೆ ಲಾಯರ್ ಹಾಕ್ಬೇಕು ಅದಕ್ಕೆ ಅವನೇ ಬರ್ಕೊಂಡು ಬರ್ತಾನೆ. ಸೊ ದಿ ಲಾಯರ್ಸ್ ಜಾಬ್ ಈಸ್ ಟು ಫೈಂಡ್ ಔಟ್. ಹಿ ಹ್ಯಾಸ್ ಟು ಡಿಗ್ ದಿ ಕ್ಲೈಂಟ್. ಹಿ ಮಸ್ಟ್ ಫೈಂಡ್ ಔಟ್. ಕ್ವಶನ್ಸ್ ಹಾಕಬೇಕು, ಎಲಿಸಿಟ್ ಮಾಡಿಸ್ಬೇಕು. ದೆನ್ ಯು ಹ್ಯಾವ್ ಟು ಟ್ರೇಸ್. After all, we are there to do justice to the client. So we have to do it. So that all depends on how, as an advocate, we develop the art. Now, what is the general exception to the general rule? The general rule is the distant kinder will get a share in the property only when there is no sharer, there is no residuary. But there is an exception. What is that exception? If the deceased has left behind only the wife, please understand this. Very, very important aspect. If the deceased has left behind only the wife, no other sharer, no residuary, no other sharer, no residuary, then the wife will get not more than 1/4 share as a sharer. Then whatever the remaining 75% is their 3/4 share, that will go to the distant kinder. That will go to the distant kinder. If the husband dies, leaving behind only the wife, leaving behind only the wife, I have already given that example, isn't it? If the wife dies, leaving behind only the husband, no other sharer, no residuary, then the husband will get half a share. Half a share. Half a husband will, if there is a child, he will get 1/4. Otherwise, he will get half a share. The remaining half will go to distant kinder because there is no residuary. So it is an exception to the general rule. The general rule is the distant kinder will get a property, will get the property of the deceased only when there is no sharer and no residuary. But this is an exception. This is an exception. I think there is something which is not, ಒಪ್ಕೊಳಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಸುಲಭಕ್ಕೆ. ಪಾಪ ಹೆಂಡತಿ ಆ ಗಂಡನ ಜೊತೆಲಿ ಸಂಸಾರ ಮಾಡಿರ್ತಾಳೆ ಅಷ್ಟು ವರ್ಷ, ಮಕ್ಕಳನ್ನ ಹೆತ್ತಿರ್ತಾಳೆ, ಸಂಸಾರ ನಡೆಸ್ತಿರ್ತಾಳೆ. ಅಂತವಳಿಗೆ ಬರೀ 4 ಆಣಿ ನಿನ್ ಭಾಗ ತಗೋ, ಇನ್ ಮುಕ್ಕಾಲ್ ರೂಪಾಯಿ 75% ಬೇರೆಯವ್ರು ಯಾರಿಗೋ ಹೋಗ್ಬಿಡ್ಲಿ ಅಂತಂದ್ರೆ, ಐ ಡೋಂಟ್ ನೋ ಹೌ ಇಟ್ ಈಸ್ ದಿಸ್ ಥಿಂಗ್. ಎನಿವೇ, ದಟ್ ಈಸ್ ದಿ ಲಾ. ದೇ ಹ್ಯಾವ್ ಟು ಅಕ್ಸೆಪ್ಟ್ ಇಟ್. Now, there is one more important principle under Mohammedan law: doctrine of Aul and doctrine of Rad. What do you mean by this? AUL, Aul, RADD, Rad. Doctrine of Aul and doctrine of Rad. If you read Article 64 in the Mohammedan Law and Article 66 in the Mohammedan Law, you will come to know what is doctrine of owl and doctrine of parrot. Not OWL. Not OWL, it is AUL. Sometimes it so happen that the deceased would have left behind so many number of sharers, that whatever the property that he has left behind may not be sufficient even to allot the shares to those sharers as per the defined share. I hope all of you have understood this. Let us say, for example, the deceased has left behind 1000 rupees, but he has left behind so many sharers that if that 1000 rupees may not be sufficient to distribute it among all the sharers who are alive as on the date of the death of the deceased Mohammedan. Then what to do? Then what to do? I can explain this with an example. I think that will be easy for us to understand. If you have a paper and a pen, you can make a note of it. Just I have only brought one example because ಬೇಕಾದಷ್ಟು examples ಕೊಡ್ಬೋದು, but because of the time constraint, I have brought only one example. Let us say, for example, a Muslim woman, let us say W, dies, leaving behind her husband, 3 daughters, and her father and mother. Once again, I am repeating. A Muslim woman dies, leaving behind her husband, her father and mother, that is her parents, and 3 daughters. Total 6 members. Now, please note, all these persons are coming in the list of sharers. If you see the list of sharers, all these persons are coming in the list of sharers. When a woman dies, leaving behind her lineal descendants, father will get 1/4. The husband will get 1/4. So husband's share is 1/4. The parents each will get 1/6 and 1/6. ಆರನೇ ಒಂದು ಭಾಗ, ಆರನೇ ಒಂದು ಭಾಗ. ಗಂಡನಿಗೆ 4ನೇ ಒಂದು ಭಾಗ. 3 ಜನ daughters ಇದ್ದಾರೆ. I told you already. If there is one daughter, she will get half a share. If there is more than one daughter, all the daughters put together will get 2/3 share. 2/3 share. So 1/4 plus 1/6 plus 1/6 plus 2/3. Okay. ನಿಮ್ಗೆ ಏನಾದರೂ ಲಾಸ ಕಂಡುಹಿಡಿಯೋಕೆ ಬಂದ್ರೆ, ಪ್ರೈಮರಿ 6ನೇ ಕ್ಲಾಸಲ್ಲಿ ಓದಿರ್ತೀವಿ ನಾವು, ಲಾಸ ಕಂಡುಹಿಡಿಯೋದಕ್ಕೆ ಬಂದ್ರೆ ನೀವು ಕಂಡುಹಿಡ್ಕೊಳ್ಳಿ. ನಾನು ಕಂಡುಹಿಡಿದಿದ್ದೀನಿ, ಇವಾಗ ತಿರುಗಿ ಕಂಡುಹಿಡಿಯೋಕೆ ಟೈಮ್ ಇಲ್ಲ ನನಗೆ. ನಾನು ಹೇಳ್ತೀನಿ ಎಷ್ಟು ಬರುತ್ತೆ ಅಂತ. ಹಸ್ಬೆಂಡ್ಗೆ 12ನೇ 3 ಭಾಗ, ಫಸ್ಟ್ ನೋಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ, ಆಮೇಲೆ ನೋಡೋಣ. ಹಸ್ಬೆಂಡ್ಗೆ 12ನೇ 3 ಭಾಗ, ಹನ್ನೆರಡನೇ 3 ಭಾಗ ಅಂದ್ರೆ 12 ಕೆಳಗೆ 3 ಕೆಳಗೆ 3 ಮೇಲೆ. ಇಂಗ್ಲಿಷಲ್ಲಿ ಹೇಳಿದ್ರೆ 3/12, ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿದ್ರೆ 12ನೇ 3 ಭಾಗ. ಹಸ್ಬೆಂಡ್ ವಿಲ್ ಗೆಟ್ 12ನೇ 3 ಭಾಗ. ದೆನ್ ಪೇರೆಂಟ್ಸ್ ವಿಲ್ ಗೆಟ್ 12ನೇ 2 ಭಾಗ. 12ನೇ 2, 12ನೇ 2 ಇಬ್ಬರಿದಾರಲ್ಲ, ಅಪ್ಪ ಅಮ್ಮ ಇಬ್ರು ಇದ್ದಾರೆ. ದೆನ್ 3 ಜನ ಡಾಟರ್ಸು, 12ನೇ 8. ಒನ್ಸ್ ಅಗೈನ್ 3ನೇ 12, 12ನೇ 3, 12ನೇ 2, 12ನೇ 2, 12ನೇ 8. ಈ ಮೇಲ್ಗಡೆದೆಲ್ಲ ಕೂಡಿ ಎಷ್ಟು ಬರುತ್ತೆ? ಎಷ್ಟು ಬಂತು? ಬರ್ಕೊಂಡಿಲ್ಲ ಯಾರು? ಎಷ್ಟು ಬಂತು? 8, 2 10, 2 12, 3 15. ಕೆಳಗಡೆ ಎಷ್ಟಿದೆ? 12 ರೂಪಾಯಿ ಇಟ್ಕೊಂಡು 15 ರೂಪಾಯಿ ಹಂಚು ಅಂದ್ರೆ ಹೇಗಾಗುತ್ತೆ? ದಿಸ್ ಇಸ್ ಎಕ್ಸಾಕ್ಟ್ಲಿ ದಿ ಪೊಸಿಷನ್ ಹಿಯರ್. You have property, but you have so many sharers that you cannot distribute that property according to the defined shares. List of sharers will say, this is the share to which he is entitled, this is the share to which he is entitled, but you can't distribute it. Because you have only 12 rupees, you have to distribute 15 rupees. From where you can do it? Therefore, the simple explanation given in 64 is, Either you increase the numerator or you increase the denominator. Sorry, either you see, it comes like this. If you make 12 as 15, 15 ಮೇಲೆ ಸೊ ಕೆಳಗೂ 15 ಮಾಡ್ಕೊಂಬಿಡಿ. ಮೂರನೇ 15ನೇ 3, 15ನೇ 2, 15ನೇ 2, 15ನೇ 8. ಯಾರಿಗೋ ಒಬ್ರು ಕಮ್ಮಿ ಬರುತ್ತೆ, ಯಾರಿಗೋ ಒಬ್ರು ಕಮ್ಮಿ ಬರುತ್ತೆ, ಬಟ್ ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ಯು ಕಾಂಟ್ ಹೆಲ್ಪ್, ಯು ಕಾಂಟ್ ಹೆಲ್ಪ್. ಸೊ ದಿಸ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಡಾಕ್ಟರಿನ್ ಆಫ್ ಔಲ್. ದಿಸ್ ಈಸ್ ಕಾಲ್ಡ್ ಆಸ್ ಡಾಕ್ಟರಿನ್ ಆಫ್ ಔಲ್. ಎಂಟು ಹ್ಯಾಕ್ ಬಂತು ಅಂತಲಾ? 8, 2, 10, 2, 12, 3, 15 ಬಂತಲ್ಲ ಮೇಲ್ಗಡೆ ನ್ಯೂಮರೇಟ್ರು. ಅವಲ್ಲ AUL, ನಾಟ್ OWL. ಅವಾಗಲೇ ಹೇಳಿದ್ನಲ್ಲ, ನಾಟ್ OWL, ಇಟ್ ಈಸ್ AUL. ರದ್, RADD, RADD, DD. Understood? This is the doctrine of Paul. That means doctrine of Paul is applicable when there are so many sharers with defined shares to be allotted according to the list of sharers, but whereas the property that is available is not at all sufficient to allot. Then the only point is either you decrease the numerator, make it equal to 12, or increase the denominator to make it equal to the numerator. That's all. I will read the section 64 for your benefit. If it is found on assignment the respective shares to the sharers, the total of the shares exceeds the unity. Unity means that share, whatever the quantum of shares, value of the property is there, that is unity. Unity. The share of each sharer is proportionally diminished by reducing the fractional share to a common denominator, or increase the sum in the numerator. Either this or that. You have to make it equal. Somebody will get less share. We are helpless. It has to be done. Adjustment will have to be done there. This is called as doctrine of Paul. Then coming to the doctrine of Rath. In case of doctrine of Rath, it so happened that there are only a few number of sharers, no residuaries. There are only few number of sharers, no residuaries. There are distant kindred. Repeat it again. In case of Rath, there are only few number of sharers, no residuaries, there are distant kindred. Now the general rule is distant kindred will get a share in the property only when there is no sharer and no residuary. But here there are sharers. There are sharers. So it will not go to distant kindred as per the general rule. As per the general rule. Under such circumstances, what has to be done? Again, you can make a note. A male Muslim, a male Muslim dies, leaving behind his mother and daughter only. Leaving behind his mother and daughter only. Now, both are in the list of sharers. Mother will get 1/6 share. Because there is only one daughter, she will get half a share. Half. She will get half a share. Because there is no son, she will get half a share. Now, half plus 1/6, half plus 1/6 is equal to 4/6 in English, 6/4 ಕನ್ನಡದಲ್ಲಿ. ಅದಾದ್ಮೇಲೆ ನೀವು ಮನೇಲಿ ಕೂತ್ಕೊಂಡು ಲೆಕ್ಕ ಹಾಕೊಳ್ಳಿ. ಗೊತ್ತಾಗದೇ ಇದ್ರೆ ನಿಮ್ಮ ಮಕ್ಕಳನ್ನ ಕೇಳಿ ಹೇಳ್ಕೊಡ್ತಾರೆ. I hope all of you got it. You want me to repeat it again? Okay. Sir? 4/6. 4/6. Now still there is 2/6 remaining. Still there is 2/6 remaining. This is quite reverse to the earlier one. What should be done with that? The general rule is that 2/6 will be given to the same sharers in the same proportion. That is the general rule. ಬಂದೆ ಒಂದು ನಿಮಿಷ. ಹೇಳಿ. ಅದು ರೂಲ್ ಅದು. ಐ ಹ್ಯಾವ್ ಟು ಹಾ, ನೀವು ಅವ್ರಿಗೆ ಕೊಡದೆ ನೀವು ಡಿಸ್ಟೆಂಟ್ ಕಿಂಡರ್ ಕೊಟ್ಬಿಟ್ರೆ, ಸೊ ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲಿ ಹೇಳ್ತಿರೋದು ಇನ್ಯಾರಿಗೂ ಕೊಡಬೇಡಿ, ಅವ್ರಿಗೆ ತಿರುಗಿ ವಾಪಸ್ ಹಂಚಿ. ಯಾಕೆಂದ್ರೆ ರೆಸಿಡ್ಯೂರಿಸ್ ಇಲ್ಲ ಅಲ್ಲಿ. ರೆಸಿಡ್ಯೂರಿಸ್ ಇದ್ರೆ ಉಳಿದ ತಗೊಂಡ್ಬಿಡೋರು, ಅವ್ರಿಲ್ಲ ಅವರಲ್ಲಿ. ಹಾ, ಲೆಕ್ಕ ಮಾಡಿ ಕೊಡಿ. ಅಲ್ಲ, ಪ್ರಪೋರ್ಷನ್ ಚೇಂಜ್ ಆಗುತ್ತಲ್ಲ. ಇವಾಗ ಹಾಫ್ ಡಾಟರ್ ಕೊಟ್ಟಾಗ ಅವಳಿಗೆ ತಿರುಗಿ ಹಾಫ್ ಕೊಟ್ರೆ ಉಳಿದಿರೋ 6/4 ಆಕೆಗೆ ಜಾಸ್ತಿ ಬರುತ್ತೆ, ತಾಯಿ ಕಮ್ಮಿ ಬರುತ್ತೆ. ಸೊ ದೇರ್ ಕ್ವಾಂಟಮ್ ಆಫ್ ಶೇರ್ ಆಲ್ಸೋ ವಿಲ್ ಗೆಟ್ ರಿಡ್ಯೂಸ್ಡ್. Now, in Mohammedan law, the illegitimate child can succeed to the property of her mother and relations of mother only, and not to anybody else. An illegitimate child under Mohammedan law. And a person who has converted to other religion will be disqualified from claiming any share. ಕೆಲಸಲ್ವಾ? Now I told you that the birthright is not recognized under Mohammedan law. For that, birthright is not recognized under Mohammedan law, or there is no doctrine of representation. For that, there is one old decision which may help you. That is Hassan Ali versus Nazo. You find in that book, Hassan Ali versus Nazo. See, the facts of the case are like this. Kindly listen to me. A has a son by name B. A has a son by name B. I told you that under Mohammedan law, there is no concept of joint family, no concept of ancestral property, no concept of co-personary property. Got it? A has a son by name B. A executes a gift deed in favor of C, giving us his property to C, thereby depriving B from any share in the property. During the lifetime of A, B files a suit, his son files a suit against A and C, contending that this gift deed is the outcome of fraud. Therefore, set aside the gift deed, because I would have been entitled to a share after the death of my father. Then the court said, the Mohammedan law does not recognize the spes successionis, that is chance of succession, which is recognized under Mohammed Hindu law. ನಮ್ಮ ಅಪ್ಪ ಸತ್ರ ನನಗೆ ಬರುತ್ತೆ ಆಸ್ತಿ, ಇದು ನನಗೆ ಯಾವಾಗ ಬರುತ್ತೆ ಆಸ್ತಿ? ಆ ಚಾನ್ಸ್ ಇಲ್ಲಿಲ್ಲ ಮೊಹಮ್ಮದನ್ ಲಾನಲ್ಲಿ. ಹಾಗಿರೋವಾಗ ನೀನು ಬಿ, ನಿನಗೆ ಸಿ ಮೇಲೆ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಇಲ್ಲ. Because A has executed a gift deed in favor of C, you have no cause of action against C. Similarly, you have no cause of action against A, because A could do whatever he wants with the property during his lifetime. You cannot question. You are entitled for a share only when your father has left the property behind and died. Your father has dealt with the property during his lifetime by executing a gift deed. So you have no cause of action. So suit was dismissed. But there is one rider added there. After the death of A, a son can file a suit against C. After the death of A, son can file a suit against C, alleging that the gift has come out of fraud. Not before that. I told you I will tell you about the false grandmother later. A false grandmother, hello, shall we stop? ಅಲ್ಲ ತಮಗೆಲ್ಲ ಬೇಜಾರಾಗಿದ್ರೆ ಬೇಕಾದ್ರೆ ನಿಲ್ಲಿಸ್ಬಿಡ್ತೀನಿ. Who is a false grandmother? I have already explained true grandfather and true grandmother. Who is a false grandfather and a false grandmother? If there intervenes any maternal grandfather, between the female ancestor and the propositus, propositus is the person who is dead, whose property is now subject for partition, division, then the said female ancestor is a false grandmother. For example, mother's father's father, mother is a false grandmother. Mother's father's mother. ಅಂದ್ರೆ ನನ್ನ ತಾಯಿಯ ತಂದೆಯ ತಾಯಿ. She is a false grandmother to me. Then false grandmother of the propositus. Then false grandmother. Cancerian and mutant brothers I have already explained. True grandfather. Or a paternal grandfather I have already explained. False grandfather. The maternal grandfather of a person is called as a false grandfather. Nanna taiya tande. The maternal grandfather of a person is called as false grandmother. She is a false grandmother. Now, after said all this, I would like to summarize it in a very, very easy manner as to how to resolve a partition suit if the parties are Muslims. See, my experience says that the suit is normally filed either by a son or by a daughter or by a wife or by a husband against the remaining sons or daughters or whatever it is. Normally, no stranger will be there. So in such cases, they are all called as primary heirs. Who are primary heirs? Surviving spouse, number one. If wife is dead, husband. If husband is dead, wife. Son, daughter, mother and father. Normally, these are the persons who will be found in a partition suit between the Mohammedans. Normally, I am just giving normal situation. You need not have to worry. You need not have to break your head because all of them comes in the category of sharers. You allot the shares to them. If you allot the shares to these people, it will exceed the total quantity of the property that is left behind by the deceased. So you need not have to take note of residuary or distant kindred. ಇದನ್ನ ಯಾಕೆ ಮುಂಚೆ ಹೇಳಲಿಲ್ಲ ಅಂದ್ರೆ ಮುಂಚೆ ಇದನ್ನ ಹೇಳ್ಬಿಟ್ರೆ ಉಳಿದಿದ್ದೆಲ್ಲ ಕೇಳೋಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರ ಇದನ್ನ ಕೊನೆಯಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ರು. So therefore, that is the most simple way in which a partition suit can be disposed of. ನನ್ನ ಅನುಭವದಲ್ಲಿ ಹೇಳಬೇಕು ಅಂದ್ರೆ ಹಿಂದೂ ಲಾಗಿನ್ನ ಲೆಸ್ ಕಾಂಪ್ಲಿಕೇಟೆಡ್ ಇದು. ಸ್ವಲ್ಪ ನಾವು ಅಪ್ಲೈ ಮಾಡ್ಬೇಕಷ್ಟೇ ಮೈಂಡ್. ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. Correct. So, got it? Any question? Yes. How to determine the paternity of a child? You can take two citations if you want. 2004 volume number 1, Karnataka Law Journal, page 142. AIR 1993 Supreme Court, page 2295. 2004 volume 1, Karnataka Law Journal, page 142. AIR 1993 Supreme Court, page 2295. Then I told you a Mohammedan cannot will away more than 1/3. To cover that, 2010 volume 5, KCCR 3998. 2010, Volume 5, KCCR 3998. And in order to understand the paternity of the child clearly, you may refer to Article 339 of this book on Mohammedan law. Whether the children of the deceased can claim a share in the suit property, held yes. 2008, volume number 1, Karnataka Law Journal, page 587. 2008, 1 Karnataka Law Journal, page 587. Then with regard to the evidentiary value of the blood test, AIR 1993 Supreme Court, page 2295. Adoption in madam? ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. Adoption is not known to Mohammedan law. Adoption is not known to Mohammedan law. ಸೊ ಯಾರಾದ್ರೂ ಕ್ಲೈಂಟ್ ಬಂದು ಅವ್ರು ನನ್ನ ದತ್ತು ತಗೊಂಡಿದ್ದಾರೆ, ನಂಗೆ ಭಾಗ ಬರಬೇಕು, ಕೇಸ್ ಹಾಕಿ ಅಂತಂದ್ರೆ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ಕೇಸ್ ಹಾಕ್ಬೇಡಿ. ಅಥವಾ ಡಿಫೆಂಡೆಂಟ್ ಏನಾದ್ರು ನಾನು ಅಡಾಪ್ಟೆಡ್ ಸರ್ ನನಗೂ ಭಾಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ ಪ್ಲೀಸ್ ನೋ ದಟ್ adoption has no place in the Mohammedan law. It's not recognized. As my Lord has already told it, a child in the womb is entitled for a share if the child takes birth alive, otherwise not. And a missing person, actually under the Sunni law, Hanafi school of Sunni law, a missing person, property of a missing person is supposed to be kept in abeyance for a period of 90 years from the date of his birth. Wait, I have not completed it. But that is no longer applied in view of the provisions of the Evidence Act, which says that where a person is not heard for a period of 7 years, either from the persons who would have naturally heard of him had he been alive, he is presumed to be dead. That is what the Evidence Act says. So, that is applicable. Just I brought to your notice, that's all. Then posthumous child. Who is a posthumous child? When a Muslim dies, leaving behind a widow, and she shall not remarry for 4 months and 10 days. That is Iddat period. And during that period, she will not remarry. She gives a birth to a child. Then the presumption is that child is born to a person who is dead. So that child is entitled for a share. That is the right of a posthumous child. Simultaneous death, I have already said. Madam, ಎಷ್ಟು ಬಂದ್ರೆ ಅಷ್ಟು ಹುಡುಗನೋ ಹುಡುಗಿನೋ ಯಾರು ಗೊತ್ತು, ಅದು depending on that. So I think with this, of course, there are a lot of things to say so far as law of inheritance is concerned, but I have tried to abridge it to the extent possible due to paucity of time. Custody. If you are prepared to hear, I am ready to deliver lecture. ಇವಾಗ ಆವಾಗಲೇ ನಮಗೆ ಬೇಜಾರಾಗ್ಬಿಟ್ಟಿದೆ ಸರ್, ಬೇಡ ಅಂದ್ರೆ we will wind up. ಬೇಕಾ ಕಸ್ಟಡಿ ಬೇಕಾ?
ಕಸ್ಟಡಿ ಬೇಕಿತ್ತು
ಮೇಡಮ್ ಹೇಗಿದೆಯಾ? ಅವರ ಡೈರೆಕ್ಟರ್ ಶುಡ್ ಪರ್ಮಿಟ್ ಮೀ. ಮೇಡಮ್ ನಮಸ್ಕಾರ. ಸುಶೀಲಾ ಮೇಡಮ್ ನವರಿಗೆ.
How about a brief talk on, you may ask questions on child custody and Mohammedan law, and that will be answered. And probably we'll have one more session on this topic here.
ನೀವು ಹೇಗೆ ಹೇಳಿದ್ರೆ ಹಾಗೆ.
Sir, one of my client has a 6 wives and 24 children. how they partition their property? Kindly tell me, sir.
Thing is 6 5. So ready. Ready? What?
You please see the chart. I have an answer to your question. You please see the chart. In the list of sharers, after the table is over, below there is some notings made. At clause B, it is mentioned the collective share is always divided equally among those to whom it is allotted. Got the answer? 10 ಜನ ಹೆಂಡತಿರಿದ್ರು ಅಷ್ಟೇ, 40 ಜನ ಮಕ್ಕಳಿದ್ರು ಅಷ್ಟೇ. It will not exceed. It equally, answer is there, equally is divided. And under Mohammedan law, one can have 4 wives. So even if a person has left behind all the 4 wives, the 4 wives will be entitled for 1 share, 1/4 share only. More than that, according to that particular calculation. ಒಂದ್ಸಲಿ ಆ ಚಾರ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ, ಒಂದ್ಸಲಿ ಆ ಚಾರ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ. Yes. Any other question? ನೋಡಿ ಅವ್ರ ಮೈಕ್ ಕೊಟ್ಬಿಡ್ತಾ ಇರುತ್ತೆ. So hope you have no questions. Madam?
Are there any questions from mediators of Dharwad bench?
No, madam, we do not have any question.
Thank you.
ಯಾರನ್ನ ಕೇಳಿದ್ವು? ಓಹೋ, ಕಷ್ಟ ಮುಗೀತಲ್ಲ. So thank you very much. I once again feel it as my proud privilege to be here in this beautiful evening, and I thank Madam Srimati Radha and also the board of governors of this esteemed institution for providing me this opportunity to come here and to share my few thoughts with you. And I'm quite conscious that I have not dealt in detail the law relating to inheritance among Mohammedans. But whatever the time that was available, within the time, whatever that I could do, I have done it. But don't think that what all I have done is the whole thing, entire thing. There is something more to be discussed, something more to be read. So please read. Now that you have an idea as to how to proceed, and with this idea and with the experience that you have, I don't think that you should have any difficulty in reading the book and understanding the things. So once again, thank you very much. Thank you, madam, for providing me this opportunity. Thank you.
Thank you, Venkat Sudarshan sir, for your wonderful lecture on Mohammedan law. We are all enlightened by your informative talk. On behalf of Karnataka Mediation Centre, my heartfelt thanks to you, sir. We request you to visit us often and share your knowledge on various law subjects. May I request to render vote of thanks by Srimati Vaishali Hegde.
We would like, I, on behalf of all my brothers and sisters here today, would like to express our deep gratitude to Justice Ashok Kinigi, Judge High Court of Karnataka, Governor Karnataka Mediation Centre, for making the time to be here and for his introductory remarks on the Muslim inheritance and custody law. Thank you, sir, in his absence. Thank you, sir, Mr. Sudarshan, for the most enlightening talk on inheritance under Muslim law. I'd like to say on a lighter vein, if only our lecturers in college had been half as interesting, I think I would have been more knowledgeable about Mohammedan law today. Thank you, sir.
I am glad we could make up for what we lost in college. And we do hope that we do get another interaction, sir, with you. Kindly do make the time. Madam Director, Ms. Radha, thank you for your initiative and your uh, continuous endeavor to make our CME programs so interesting and so well attended. Thank you, Madam. Our Deputy Director, who's always so encouraging and quietly behind the scene, was a pillar of strength. Thank you so much, sir. The Assistant Registrar Generals of Dharwar and Gulbarga Bench, thank you for joining us through via VC. And I hope we all are an enlightened lot today. And to the staff of the Mediation Centre, thank you for your cooperation. Brother and sister mediators, we are actually going back with a lovely smile today. And I see that most of us are still here. I can tell you from experience, sir, that is a very great compliment to you. Otherwise, by 6 o'clock, everyone is there. Thank you so much for being here. Until the next CME. Thank you.